Next on the calendar is number 117, People versus Sparkle Daniel.
Good afternoon. May it please the Court. David Stromes for the Manhattan DA, assigned as Special Prosecutor for the People. Your Honor, may I reserve 2 minutes for rebuttal?
You may.
Thank you. The Appellate Division in this case erred as a matter of law when it found itself bound by this Court's precedent, that this Court's precedent left it with no alternative but to suppress the statement at issue. And that finding was incorrect. In fact, this Court's decision in People v. White, which the Appellate Division did not analyze, provides a compelling basis to permit that statement in.
Aren't all of these questions mixed questions of law and fact?
These are not. To be sure, most are. The very existence of this Court's decisions in White and Pullman and Chappell prove that there can be the case that makes it as a question of law. And the reason that this case rises to that level is because the Appellate Division didn't traditionally, as happened in the companion case, Panton, cite a bunch of factors, balance, and say, therefore, we find this way. It felt that it was stuck. It said, we have no alternative based on People v. Pullman but to reverse. We are compelled to reverse. And it even noted explicitly.
Can't we infer that the Court felt that looking at all the factors, it led to that inevitable conclusion?
That may well be the case if there was actually evidence that it had looked at all the factors. But the factors that White established, which Pullman did not address or Pullman did not develop, are dispositive in this case, weigh strongly in favor of permitting the statement. When you look in particular at the facts of White, White prevents an even better case for suppression than this one does. And what White emphasized in particular was the fact that in that case as here, the extent and duration of the unwarned exchange was very brief, was de minimis, that the statement that the defendant made before warnings was innocuous, that the first statement that the defendant gave after receiving and waiving Miranda warnings was actually exculpatory, and that there was a change in tenor from before the warnings to after the warnings. When after the warnings were given, you had your typical structured interrogatory question and answer session, which was not the case before the warnings. And the Appellate Division, just ticking off the few factors that Pullman delved into, listed those, same interrogator, same place, not a lot of time, and said, we're stuck. There's nothing we can do. We have no alternative but to reverse. Had the Appellate Division explored White to the depth that really the case required, the outcome
Why couldn't we read what the Appellate Division did as looking at the facts as you stated them, counsel, and as the court, the Supreme Court stated them, and just drawn different inferences about whether the statements that the police officer made initially was designed to elicit an incriminating statement, and the other inferences that follow from the rest of the statements? Why couldn't we look at the Appellate Division decision in that way?
Your Honor, I don't have to dispute any of those inferences that the Appellate Division drew. Based on the face of its decision, I think, again, contrasting it to something like the companion case Panton or to any of the hundreds of cases that over the years have been the routine application of the Pullman-Chappell standard, those cases all look the same. This case looks different. It is rare. I'm not sure I've ever seen the Appellate Division say Court of Appeals precedent leaves us with no alternative but to reverse.
Well, but that could be a rhetorical device rather than an analysis of the Pullman factors.
It might be if it were isolated, but it happened 3 times in this case. They said
so
that.
You think, what were they saying, that they disagreed with our decision?
That they disagreed with Pullman? I'm not sure they expressed an opinion as to the merit of Pullman, but they certainly felt that Pullman constrained them to rule a certain way.
I mean, isn't that the question that you're – if we say under Pullman that's what you do and they do it, what's –
because Pullman is not the only case to analyze. White is a more recent case.
They made factual determinations. How do you know? We're not going to change those, obviously.
Certainly, and as long as I don't challenge those factual determinations, I don't think I'm in trouble on the mixed question.
Right. So you want us to say, based on these facts, but applying White instead of Pullman, the decision should be that the Supreme Court should be affirmed?
It's not about White instead of Pullman. It's about considering White in addition to Pullman, because I think what the appellate division didn't do, White and Pullman together, you get about 8 factors. Okay? 4 explored in Pullman, 4 explored in White. The appellate division stuck to the Pullman factors without looking at the White factors. But what it didn't do, what it was required to do as a matter of law, was look at all 8.
Should we send it back then?
I don't think you need to send it back. Once the court has jurisdiction, it can decide that question, just as it did in White.
Counsel, on the White question, which I agree is closer here, if you line up the factors in White with your case, the one thing that seems to me to be missing, and maybe I'm missing something in the record, is there was this break, which timing-wise I think is similar, but there's kind of this activity during the break where they have a soda, he smokes a cigarette, it kind of takes the temperature down, I guess, really. And I think in White, because the factors are, maybe let's say White is out here, that seems to me fairly important in the White analysis. And what is there in this case that's analogous to that type of break in the temperature or the tenor of what's going on in the same room with the same people?
So certainly there's about the same time break as in White. White was 15 minutes. This was about 15 minutes. Now, you're absolutely correct that in White there was this get me the cigarettes and the soda. That's one factor to be balanced among the rest. And what you had in White was the pre-warning exchanges before the defendant said that. The defendant was actually interrogated. The officers asked him, "Do you want to? How about you tell your side of the story?" After showing a crime, showing a photograph of the victim and saying he was either murdered in cold blood or there was a reason for it. And then the defendant said, "I'll tell you everything. Just get me those cigarettes and soda." Here, it was so much more de minimis than that. The time alone really is sufficient to know that the defendant was able to reset herself. And in fact, when he came back in, the way she started volunteering that statement, he said something totally innocuous. He came back in as almost a "where was I? I know you know what I'm talking about." And she just starts talking. To volunteer like that, she had thought over the break. She had reset herself, and she had determined that she was going to say something.
Point. You read it as sort of an innocuous, where was I? And then on the other hand, it can be read as, okay, you know what I'm talking about.
Well, I think the best answer to that is People v. Huffman. If it is not the functional equivalent of interrogation for an officer to tell a defendant after he had denied guilt and then been picked out of a photo array by the burglary complainant to come back and say you're a liar, and he says you're right, you got me. If that's not interrogation, certainly neither is, you know what I'm talking about.
Well, counsel, on the issue of the timing, I'm wondering how you're calculating the break. You said it's 15 minutes, but I'm not sure about that as I looked at this record.
I think it's about 15 minutes. The facts are that the detective, when he first came into the room, it was 6:55. That was a finding of fact by the trial court. He said literally a sentence and a half to her before he was pulled out. So if you want to generously give that a minute, we can, but it can't take very long. And then there was a finding of fact that Miranda warnings were administered at 7:10, very, very quickly after he came back in. So based on those trial court's findings, which the appellate division did not disturb, that's where we are. Whether it's 15 minutes, is it 14 minutes, I would submit it doesn't matter at that point.
Thank you, Mr. Strauss.
Thank you.
Counsel?
Natalie Ray for Ms. Daniels. Of course, we disagree. I'll go with facts first.
Take us straight away to the, White.
To White. This is so much more egregious than White. First, I would say it's a mixed question. The people are trying to re-argue White. In White, the court said, they're saying that the brevity of the questioning and the lack of, because it's not a confession, then that's the end of the analysis. What this court precisely said in White is, no, it's one factor. The appellate division did exactly what it was supposed to do in this case. It identified the controlling authority, Pullman, and it cited to White. It looked at all the factors, and it decided, yes, it had no alternative. It wasn't a legal question. It had no alternatives because of the facts. Because the facts here, unlike White, they were all, it was all set up and designed to get a confession. Let's start with the arrest. The detectives didn't get a warrant and go to her house to arrest her. They waited for her to show up on the street. Then they arrest her in what even the detectives have to agree was not was agitated. There's a crowd comes around. She's handcuffed. She's put in a detective car. She drives to the Bronx for
There's no issue of custody here.
No, but I think it goes directly to separate the isolation and the pressure and the length on the impact on the defendant. Obviously, that's important to the impact of the un-Mirandized questioning. It doesn't, in White, there was...
What do you say about the timing of...
Well, the timing, I'm afraid to say, I have to correct, because the timing is not between the notes of the police officer when he came to the room and after she had been in handcuffs in custody forever, where the question is the timing between the un-Mirandized questioning and answer and Miranda. So here, and I'm going to read from the record, he stepped out for a couple of minutes. We actually don't know what happened in the 15 minutes between the 6:55 when he put her in the room and the 7:10. All we know is police officer says you know why you're here? She says no. I'm reading at the appendix of the People, page 100. Line 3. I asked her if she knew why she was here. She said no. I told her, I said, we're investigating a murder of an old lady. At this point in time, I'm interrupted. I step out, and later on he says it'll be for a couple of minutes. Comes back in. When I come back in, when I said to Ms. Daniels, do you know what I'm talking about now? And he goes further on page 101 and says, as I recollect, I asked her, do you know? I believe I said, I know you know what I'm talking about now. In other words, he said, there's no, and then he says, then she answers, she says yes. She said, I went on to say her and Nadine went to her aunt's house, saw the victim, I believe, and asked it for her. And only then, when she made that incriminatory statement, then he said, then I stopped her and Mirandized her. There's no stop. In general, these cases come up where they're different cops, they're different places, they're different questionings, and the courts try to figure out whether, in the totality, it's a single event. In this case, there's no question that it's a single event. What they're trying to say is make it a non-single event by saying that the statement, that the questioning wasn't enough. So comparing White, I go back. She's arrested in this case. She's never told. She doesn't know why she's going to the station. In White, he did. It was a DV case, right? So he's brought to the station by one officer. Miss Daniels is arrested. She's put in the car. She's with these two officers for the next 7 hours, right? So Mr. White apparently was somewhat intoxicated, and he sleeps for 17 hours. Fine. Then he's put in a lineup. There's a break here, but he's put in a lineup. He's the one who asks, why am I in a lineup? Ms. Daniels showed no willingness to speak, which is a very important part of the Pullman standard. She didn't even want to give them her name when she was arrested. And then when he asked the question first, then there's no change in venue. There's no change in detective. There's no change in questioning. And there's no willingness to speak. And under Pullman, you look at the circumstances of the arrest, of the Miranda violation, which comes after this arrest and the custody and the drive to the Bronx, and she has no idea where she's going. And then White adds the nature of the statement, but again said it's one factor. Now, for the people and the dissent in this case want to say that this was not incriminating. I would beg to disagree. Where she's being asked about the murder of an old lady 4.5 years earlier. She puts herself at the scene with the co-defendant and identifies the crime. Of course it's incriminating. I don't know what more you need to do. And then there is seamless transition for Detective Chufi. I Mirandize her, and then I ask her. Now, in White, again, he was willing to talk. And he says, why am I in the lineup? They show him a picture of the victim. He says, what's with him? What about him? I mean, the attitude is completely different. Then when they ask, okay, whatever the question was, He then says, I'll tell you everything. Even that statement, he wasn't tied to anything. I'm not, in other words, she was much more, she put herself, Ms. Daniel put herself at the scene, at the time, with the victim and with the co-defendant. It's very different than what White said, right? And then
I'm sorry, did she put herself with the co-defendant? I didn't see
Yes.
that. I thought she put herself at her aunt's house.
No, no.
And at Ms. Nellie, I saw, so.
If you go to 105, actually, that's where he says it. I have that one in front of me.
Okay.
Well, so it's 101 of the record and 105 of the hearing. I said yes. In case I know. So this is the second question when he comes back in the 2 minutes. I'll go back. There's no 15-minute break. What's more disturbing here is there's 15 minutes between the time he came in and the Miranda, and all we know is that he asked 2 questions. I don't think he asked only 2 questions during those 15 minutes, and there is no break after the incriminating statement. So I'm going to read the statement, Your Honor, at 101.
Okay.
Right? He says, as I recollect, I asked her, do you know? I believe I said, I know you know what I'm talking about. And she said yes. And then she went on to say, her and Nadine went to her aunt's house. She saw Miss Nellie, and I believe is the way she described her, and asked her if she could use her phone. Now, the people also are suggesting that this was not interrogation. This is interrogation. I mean, first of all, interrogation, you go back to the idea that, as the court said in a footnote, the question is whether it was, the police thought it was reasonably likely to elicit an incriminating statement. Well, we go all the way back to the isolation, which are all from the arrest, which are very relevant to whether it's an interrogation for Miranda purposes. When he comes back and he says, I know you know what I'm talking about, he's saying to her, don't give me that no answer again. Of course it's interrogation. Of course it's elicited. He wanted to elicit an incriminating statement. And when he said, I hope so, that was just a confirmation that he had done exactly what he intended to do, which is elicit this statement.
Right. Would you like to address the subsequent statement?
The post-Miranda. So post-Miranda, there she is, she's placed herself, unlike White, where he just said, I wasn't there. I was somewhere else. I was in Queens at 7:30 or something. She had said something. So she's there. She clearly minimized her involvement. But even in the first statement, I would suggest that the court should look at both number 1 and number 2 statements that were just 7 minutes apart. And if I may say, all this time, he could have given her Miranda warnings, right? And so then
What lens are we to look at it through? Is it this is a mixed question of law and fact, or is it just a pure question of law as your adversary argues in the brief?
I think this is a mixed question. There's nothing in the language of the appellate division that suggests it's a question of law. When it said we have no choice, it had no choice because, unfortunately, it recognized your authority. And when at the end the court says we're compelled to suppress all the statements, what it was adding is the videotape also comes out because the people clearly never even thought they had an argument to challenge the fact that it was part of a single event. Therefore, we would ask the court to dismiss. Thank you.
Thank you. Counsel?
I'm going to pick up right there with that video because the proper remedy here, if this court believes that this is a mixed question, would be to send it back to the suppression court for determination on that video. The prosecutor at the suppression hearing absolutely argued that the video was even further attenuated from the statements that we've been talking about, the written statements. It's pages 291 to 292 of the hearing transcript. The prosecutor has just finished talking about the second statement ending at 827, and the prosecutor said, then at 11:15 she has the video statement, and in the interim she's left alone. She's not continually in Shufi's custody. She is given food, is given drink, is given bathroom breaks, is then brought to the prosecutor's office. And the prosecutor in that different location reads Miranda rights. She waives Miranda rights and gives another statement. that could not have been anything but an argument that the video statement is even further attenuated, and the trial court didn't rule on it because it didn't think it had to. It found that the written statements were sufficient. I understand that I have a La Fontaine problem to argue to this Court. Please go ahead and just find the video statement attenuated, even though it's so classically attenuated that there's really no issue. Post-Concepcion, though, this Court has made clear that the remedy in this kind of a situation, the people are entitled to have that determination by the suppression court based on the facts adduced at the suppression hearing. That's People v. Garcia, 20 New York 2nd, 317. So at the very least, it should be sent back, because honestly not to do so is literally to let the defendant get away with murder. That video statement is so classically attenuated. She repeated her confession, and the jury rightly heard that, and that rendered anything about the earlier statements the jury heard to be completely harmless.
We don't deal with this, for the sake of the argument, attenuated statement, then the proper remedy, if we agree with the defendant, would be dismissal, wouldn't it?
It would not be dismissal. It would be for a new trial. The people had other evidence.
Okay.
I think I can fairly argue, as we did in the brief, that this could be viewed as harmless error for all the problems with Larissa Kirby's testimony. That I understand she ended up getting money out of this. I understand she had a motive to set this person up. But if she's going to set someone up for a murder, and then all of a sudden her fingerprints are at the scene of the murder, fresh prints, that doesn't mean you set them up. That means that she actually heard on the phone what she claimed to have heard. It made all of her testimony rock solid credible. And that's the same admission that defendant ended up repeating. So the fact that the jury heard it out of Larissa Kirby's mouth was a suitable proxy given that fingerprint. So absolutely would have to get sent back for a new trial unless this Court finds it harmless. And in the event that this Court finds there to be a mixed question, the proper remedy, again, is to have that video statement examined by the suppression courts in accordance with Garcia and the principles of fairness and justice.
Thank you, Mr. Strom.
Thank you.
Next on the calendar is number 118, People v. Nadine Panton.
Good afternoon, Your Honors. My name is Robin Achinsky. May it please the Court. I represent appellant Nadine Panton. Nadine Panton, in this case...
Achinsky, excuse me for interrupting. Would you like any rebuttal time?
Oh, yes. Thank you, Your Honor. I'd like to ask for 2 minutes of rebuttal time. Nadine Panton was subjected to a tactic that this Court has condemned. She was first deliberately interrogated without Miranda warnings until she broke down and cried.
Did she challenge this, make a suppression motion for the statements based on that argument?
Your Honor, we submit that this was preserved, that defense counsel said again and again that the officer came in at 9:12. She made a statement in that time between 9:12 and 9:20 without Miranda warnings, that it was continuous chain of events and that there was no attenuation here.
You're talking about attenuation, or defense counsel talking about attenuation from the arrest. Wasn't that the argument?
Well, that was part of the argument, but I believe that he also was including the fact that there were no Miranda warnings and that there was questioning that went on during this time period. He could have been more articulate, but he did set out all the facts in his papers and in his oral argument. In the oral argument, he followed directly from the co-defendant who had made that argument, and he preserved it by noting all of those facts and by saying all the right words, including the facts of what happened here, that there was no Miranda in discussion. If this Court doesn't agree with that, I would say that it's absolutely ineffective assistance of counsel.
But then why wouldn't it be a 440 subject as the appellate division found?
Because it's obvious from the record, Your Honor. There's just absolutely no legitimate, reasonable strategy that could have justified not raising this meritorious issue. It's like the Claremont case, where he should have raised this issue. He had, it's a substantial issue.
He raised a lot of suppression issues. It wasn't that there was no request for suppression.
Well, Your Honor, he did obviously see, and it was true, that this confession was the crux of the case. I mean, this really was the case against Nadine Panton, even less so than with her co-defendant. He saw that it needed to be suppressed. He just didn't, assuming you don't find preservation, appreciate how substantial the Miranda issue really was.
No strategic reason he could have been thinking of?
I don't know if he had a reason. I can't say what it is, but I can tell you this is an argument not made in front of a jury, made in front of a judge. And he could very easily have said, I have another argument, but in the alternative, I join in the Miranda issue. There's just no justification. There's no downside for him not to have done that, and that is plain on the record. It's a substantial issue, and the confession is the only thing in the case.
If this statement had been suppressed, would that be a clear winner? Would that be the kind of Turner case that we say would amount to ineffective assistance of counsel, that it has to be a clearly dispositive issue?
Which statement?
The statement.
If all three, because there are three statements in this case.
Right. So if any of them, what are you saying about the ineffective assistance of counsel that would require us to reverse this conviction?
I'm saying that counsel should have argued that because of the Miranda warnings, because there was interrogation here, unlawful interrogation, and there was no attenuation, all of these three statements should have been suppressed. And the fact that counsel, if you find this was not preserved and he did not raise these, they should all be suppressed. Based upon the record, there is no legitimate strategy to not do that. So it would be ineffective assistance of counsel as to all of the arguments.
As we asked your now opponent on this case, why isn't this a mixed question beyond our review?
Well, Your Honor, this case is different from the co-defendant's case. In the co-defendant's case, the panel, the appellate division panel, had the law right, and they had the facts, the record facts that supported the correct analysis of the law. In this case, first of all, there was no record support for attenuation here. If you look at the factors laid out in Pullman and White to figure out when there should be attenuation, you see that there was no pronounced break here, so there was no record support in this case. And in addition, the appellate division found the law incorrectly. It found that deliberately eliciting crying that was used by the DA repeatedly at the hearing and trial was not incriminating, and then it said it relied on only that fact and then said attenuation. So it didn't do the White analysis. White said whether something is incriminating is only one factor. You have to look at everything else. It was incriminating here. The Court was wrong. But even if it hadn't have been incriminating, the Court should have gone on and analyzed the other factors. They didn't do that. So they weren't correct about the law, and they would not have been able, had they done the proper analysis that this Court mandates be done. There is no record support for attenuation in this case. If you go through the different factors.
Is there no record support? Because did the people have an opportunity to argue what the attenuation would have been since this claim wasn't raised other than to state the facts in the suppression motion? I mean, if there had been, there's no attenuation here made as a specific argument, wouldn't the record have been more complete as to why there was attenuation? But to say that, well, we laid the facts out, so we made the argument, I mean, was there any counter-argument by the people that there was attenuation?
Well, Your Honor, they actually had quite an opportunity to argue attenuation. The defense counsel specifically said there was no break.
But I guess my question is,
I'm sorry,
my question is, did they make a responsive argument that there was attenuation at the suppression hearing?
At the suppression hearing, they said that it was not custodial interrogation, which it was, and they said that the Miranda warnings were given. They did not make a sufficient case for attenuation. It's true.
Maybe they
So-
didn't know they had to, I guess is the point, since it
I think
wasn't
they knew they had to,
specifically
Your Honor.
raised.
I think they didn't. I think that defense counsel said that there was no attenuation here. He said it was one continuous chain of events. Whether you find it was for the right reasons or not, he said all those things. And the court just ignored it. The court said it wasn't incriminating and therefore attenuation. And that is the wrong rule of law. And in fact, in this case, if you look at the factors, there was 0 time inferential, all the same personnel, no change in location, no willingness to speak to the police beforehand. There was trickery and shock, I would say. She was brought in on a ruse. She was then shown a photo. She started to cry. They knew they had her. They gave her Miranda. They immediately got one statement. 2 hours later, 2.5 hours later, they got the next statement, but they didn't even bother giving any evidence as to what occurred during that 2.5 hours, and that's their burden, and they did not fulfill that burden.
Thank you, Ms. Nijinsky.
Thank you.
Mr. Stroms, at what point was Ms. Panton in custody?
I'm sorry?
At what point was Ms. Panton in custody?
I'm sure she was in custody from the moment the police arrested her. But she was in custody from the moment the police arrested her. I think Judge Garcia cut to the bone of this issue. To answer Your Honor's question to Ms. Nijinsky, no, the people never argued and never had occasion to argue at the hearing that there was a definite break in an interrogation that would have insulated post-warning statements from pre-warning statements, because the Miranda claim that defense counsel raised in this case was totally different. He can't preserve a claim as to all Miranda issues by saying the word Miranda. Instead, he put his client on the stand, and his client told a narrative of events by which the police officers told her, if you don't make a statement, someone else has implicated you in a homicide. If you don't make a statement, you're going to jail for the rest of your life and you're never going to see your kids again. And she started crying because she said she was upset by this. And they wouldn't let her go home. So she made a statement so she could see her kids, so to fulfill that bargain. And she was never read Miranda rights. So the argument was actual coercion and Miranda warnings were never read. And then she said that she initialed a form without reading it that she imagined may have been that. So when the people responded below, we responded to those claims. No, no, no. Detective Shufi was credible. Here's how you know. No, no, no. Of course she was read Miranda rights. Actually look at the form and the way that she answered the questions by writing out her responses. You know that she's credible. And you know that she was read her rights. There was never an argument by the defense that the act of crying was any sort of acknowledgement of guilt. In fact, defendant testified to the opposite. She said, I cried because I was scared.
So why isn't that ineffective?
It's not ineffective, Your Honor, because this was not going to win her the day. As Judge Abdul Salam said, this has to be clear-cut and completely dispositive under People v. Turner. And at the end of the day, even if arguing the definite break gets suppression of the written statement, it doesn't get her home clear from the video. Because the video is way down at the other end of the tunnel, an hour and a half later, different location, different interrogators, and that's going to be classically attenuated. So just getting suppression under the Chappell-Pullman test for the written statement, it doesn't get her anywhere. On the other hand —
You know what went on between the statements and the video?
Between the statements that
Statements and the video.
she was left alone for a time, then transported to
No
the
one
DA's
was there?
office. I'm sorry?
No one came in
We don't,
by herself?
Again, we don't know. We don't know because this wasn't the claim the defense attorney pursued. This is not just the kind of preservation where they were supposed to say some magic words and they didn't. This is the type of preservation, as Judge Garcia noted, where we don't even have facts because that's not the claim the defense attorney raised. Defense attorney raised a claim that would get him home free. If her testimony was found credible and she was coerced, if you don't make a statement, you're never going to see your kids again. You're going to jail for the rest of your life. And she then makes that statement. And her testimony is, and they then wouldn't even let her go home. They said, we have to get this on tape. You can't go home yet. We're going to talk to the DA. She's coerced that whole time. So if the coercion claim flies, she goes home. That's his clear win. And that's the shot that he took. And I would suggest, I'm speculating here because we haven't done a 440, but I would suggest that that was probably his strategy determination. And if the defense wants to challenge that now, a 440 hearing is the vehicle, because there is that was an obvious clear winner if she had been credited, but she wasn't. Whereas the claim that the Chappell-Pullman claim was not. That wasn't going to go anywhere because the video statement was going to be a full stop at the end. beyond the issue of preservation and the kind of preservation that leaves us with an inadequate record to even decide the claim, I would argue that this is in fact a mixed question. The reason for that is that the defense, in particular, is challenging inferences that the appellate division drew. The appellate division obviously found the act of crying to not be incriminatory. The defense has a different view of that and thinks it was incriminatory. That's a judgment call that the appellate division has the power to make. You're drawing an inference from a fact, and the appellate division drew it one way, which makes sense given the testimony that Panton herself, in fact, gave at the hearing. And the record also supports the notion that there was that 18-minute break from when she started crying to when she eventually composed herself. And the appellate division found that as a matter of fact. It's supported by the record. And at that point, there's no further review by this Court. Your Honors, just give me a minute to scan over my notes to see if I've missed anything. And the people did note in this case as well the attenuation of the video statement in the context of a patent violation, because the other claim raised at the hearing was that there was a patent violation. So we know that the defense attorney knew the video statement was going to be tough to overcome because it was part of that patent analysis. So it seems that there was a clear strategy staring that down at the other end of the tunnel, that you go for a different kind of Miranda defense. That was the issue that were raised. These issues, that the Chappell-Pullman issues in this case, simply were not part of this case, have never been part of this case, are not part of this case now.
Thank you, counsel.
Thank you.
Ms. Nijinsky?
Your Honors, I just want to note in the record, starting on page A350, 351, the prosecutor does argue that, makes her arguments about how this is not custodial interrogation, makes the arguments about that it's not attenuation, and talks about the video. She definitely talks about the statement, and she talks about the video, and she's trying to argue that it's all attenuated. She did not fulfill her burden to establish exactly what happened during that time period. But during the time period between the statement and the video statement, but she clearly was focusing on attenuation. And if she did not discuss what happened in that time period, that was her error in this case. She took, we know that Sparkler Daniel ate Chinese food and had soda, and that the officers left the room because they went in to interrogate my client. But we don't know what happened in that 2-hour period, and if you look at the video, it looks like she's sitting there with a roll of toilet paper like she had just finished crying. The officer is sitting right next to her. There was clearly an influence of that officer still present before her. So I would argue that they knew that they had to establish attenuation because the defense lawyer said there's no attenuation, there's a continuing chain, and she was under the influence of that questioning all the way through with no pronounced break.
Was the thrust of her suppression motion, as was just described, that you told me I couldn't go home, you told me I'd never see my children again? There was not an emphasis on even Miranda. It was coercion, was the theory of the suppression motion. So why would the prosecutor have to explain attenuation in terms of a break in Miranda warnings?
Well, they do discuss how she's given the Miranda warnings again in the video.
Right.
Talks about how she's calm in that video. So the defense counsel did argue that this was a continuing series of events, that there was no pronounced break, and that there was no attenuation. And the DA was responding to that, in talking about the first post-Miranda statement, and was responding to that in talking about the video.
So your position is there was an alternative argument made by the defense counsel, that either you never gave me Miranda, you told me I would never see my kids, I didn't know what I was signing, or you Miranda, you interrogated me, then you Miranda's me too late. So there is in the record showing that defense counsel made those two separate arguments in the suppression hearing.
Yes, Your Honor. It wasn't the clearest, but the facts were set out, the statements, there are a continuous series of events, the statement that there was no attenuation, that she made a statement without Miranda from 9:12 to 9:30, were all there. And he argued orally right after, and he perhaps assumed that he was just continuing a discussion and didn't utter the words. But if you look at the language, it's clear that that's happening, and the DA responded to some of those facts, too, when she argued in her, in response.
Thank you, counsel.
Thank you.